Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Erica Adler, shareholder and leader of the healthcare practice at Retzel and Andrus. I'm joined by my fellow shareholder and member of our healthcare group, Christina Kuda. Today, we're providing an urgent alert for those that are either operating a hybrid concierge practice or thinking of starting a hybrid concierge practice regarding some changes in the law, changes in the regulations of which you need to be aware. And this is specifically intended for hybrid concierge practices, which would be those that accept insurance and or Medicare, in addition to charging some type of concierge fee. So these are the type of practices that this alert is for. And what we want to talk about today is some new activity with regard to Medicare and commercial insurance contracts and PHOs, and give you some guidance on what you should be thinking about. So Christina, get us started.
Hi, so let's talk first about Medicare. There have been some developments in Medicare that happened earlier this year, and there's not been a lot of discussion that I've seen sort of in the hybrid concierge practice world on these particular changes and how they actually may impact these hybrid practices. So Medicare issued some what they're calling advanced primary care management services codes. There's specifically three: G0556, G0557, and G0558. And these codes are intended to offer sort of a monthly bundled fee for which physicians can bill Medicare related to certain what they're calling advanced primary care management services. And interestingly enough, some of the prior management services type codes that Medicare had required specific conditions, that a patient had 2 or more chronic conditions and met certain criteria in order to justify a physician being able to bill these particular codes. And while 2 of these codes do still require some chronic conditions, one does not. There is no basic criteria that the patient must meet for a chronic condition or having a certain kind of medical problem or concern in order for the physician to bill these codes. And things these codes cover include patients having 24/7 access to the practice, alternative treatments to office visits, such as home visits or expanded hours outside the practice's normal service hours, and also coordinated care with other providers and assistance with referrals, assistance with specialists, managing care while a patient is in the hospital or post-hospital. Traditionally, many of these types of services are things that were not covered by Medicare or only covered by Medicare in very limited circumstances. Accordingly, a lot of our hybrid concierge practices were offering these type of services for an additional fee under the thought that they weren't covered by Medicare. Now it's possible they are covered by Medicare. So as we've discussed before in prior podcasts, if you are not opted out of Medicare and gone through the formal Medicare opt-out process, and you see a Medicare patient, you must bill Medicare for services that are covered by Medicare. You cannot charge a patient cash for those services. So like I said, there's not much discussion on this currently, but there is a question and a concern whether or not some of the typical hybrid concierge services that practices have currently and are charging patients, Medicare patients, cash for, actually fall under one or more of these new CPT codes, and therefore the practice needs to bill Medicare for those services and cannot bill the patient cash directly.
Okay, so if you have a hybrid practice where you're seeing Medicare patients, these may or may not be the type of codes that you're coming across. A lot of practices would not actually be dealing with these type of codes at all. But if they are, what we're recommending really is that you talk to counsel and make sure that you're understanding how to handle it properly and that it is not putting you in a situation where something you're charging a concierge patient for would be something that Medicare is actually covering, correct?
Exactly.
Okay, perfect. All right, so let's keep going. What's happening with commercial insurance as it relates to these concierge practices?
So we have noticed a trend somewhat recently where commercial insurance contracts have been amended or new contracts have been changed to sort of try and hit on concierge type services. And recently, we have individually, and I know other healthcare attorneys in our field have as well, come across provisions in commercial insurance contracts that say things like you cannot charge an access fee for our patients, meaning that you can't tell a patient, yeah, I accept like Blue Cross, for example, but in order for you to be seen for a Blue Cross covered service, you have to pay this concierge annual fee. That's considered an access fee and not allowed. And I actually had a practice that did that and got a call from an insurance company the next day saying that they were terminating their provider contract because the contract specifically said you cannot charge an access fee for the patient to be seen by the practice if you are a participating provider. We've also seen a number of terms and agreements now that say you cannot treat insured beneficiaries under an insurance contract differently than other practice patients when it comes to appointment times, direct access to a provider, scheduling for services, etc. Broad interpretation of that is you can't tell our patients that they can't be seen same day or they can't be seen maybe from preferred hours, preferred times, because they are not paying for a concierge component to your practice. Another term that I recently came across, which was interesting, was in a PHO, a physician hospital organization agreement. In brief, those are generally agreements where providers become part of the PHO, the physician hospital organization, and that sort of organization is used to negotiate insurance contracts. I just saw one recently with a very large hospital system here in Illinois that specifically said if a practice is charging any concierge fees to a patient, even if it's for services that are not otherwise covered by insurance, they cannot be part of the PHO at all. And in many areas of the country, a lot of practices are sort of participating providers in insurance through these PHO agreements. So that's a very significant provision, particularly because they took the time to make it very clear that a concierge fee cannot be charged, even if it's for services that are never covered by insurance. So insurance contracts, PHO agreements, we're seeing changes that essentially are making it more difficult for practices to have a hybrid type concierge practice where they charge these extra fees but are still taking insurance and acting as participating providers.
Okay, makes sense. So you really need, when you're either operating your concierge practice or setting up a new practice, to look very carefully at your commercial insurance contracts and to look at the services that you're offering to make sure that it's not being prohibited. But it's not enough just to look at it before you start your practice. Obviously, these are being changed and updated. And I know with some commercial insurance, they just tell you, it's updated annually and they don't actually give you a copy of it. So it's possible that it gets even snuck in there and you don't even know that you're violating it, right? So you kind of want to stay on top of that if you're going to have a concierge practice. As Christina mentioned, we did have one practice. They got a call the next day. And where do you think they found out about it? Patient.
So yeah, the patient complained. The patient said, I'll pay this fee. And that afternoon, she called the insurer. This is a large national insurer, called them and said, I was told I have to pay $1,500 a year to be part of this practice now for these non-covered services. And the insurance company was very quick to contact the provider and say, that is absolutely in violation of the terms of your participating provider status.
Right. And I think to that point, the communication to the public and to patient about what you're charging them for, what's included, what's not included, and the terminology, right? So what one person considers an access fee, another person might not, but the terminology when you're throwing around words can be very important and can trigger a reaction, even if it's actually not what was intended at all. So terminology, the actual written contracts, the communication with patients, these are really important. You should be talking with your counsel about any documentation of what you're doing and any patient contracts that you're having signed to that effect. All right. So what are the final takeaways that you want to share here?
So there's a few things I think just overall everybody should consider when they're having a hybrid concierge practice, and definitely talk through with knowledgeable legal counsel. The first thing is you have to look at the services you're providing for the concierge fee and double and triple check that they are not otherwise covered services by Medicare or a commercial insurer. Two, patients should be given the choice of whether they want to be part of the concierge program. Don't make it required for access to treatment. That's generally considered an access fee. And we've seen where it's out and out prohibited. In other instances, it's disfavored. So that's one thing to consider. Another one is to carefully review your insurance and PHO agreements. I know it's tedious. I know you don't want to spend legal fees in order to have an attorney review, but it is critical because these are like little tiny terms buried in paragraphs that if you're not really looking at the agreement closely, you may miss that something you're trying to do is actually prohibited. And oftentimes, if you do something that's prohibited, the insurer has the ability to terminate the agreement, many times not even with an opportunity for you to cure a breach. Also, consider if you're in a position to have a cash-only practice where the providers are opted out of Medicare and they're not participating in any commercial insurance. This is certainly the safest way from a contractual perspective, not having to worry about breaching any of your commercial insurance contracts, also not having to worry about overstepping the Medicare rules and charging for something otherwise can't charge a Medicare patient for. There's a lot more flexibility in a cash-only practice, and it really does minimize your exposure if it's something that your practice is in a position to do.
Okay, perfect. And then one last question. If you were to reach out to an insurance company and ask them to confirm whether or not you're allowed to be concierge, I know some of our practices have tried doing this. Is this something that they usually will respond to or give you something in writing, in lieu of having to dig through their contracts?
On occasion, but it's not universal. And my concern on that as well is it takes a lot of time. So it's not like you can just call up Aetna, for example, and say, I'm just wondering if it's okay to do this. You have to get to the right person. There's usually a contracting department. Somebody has to go to their legal department. So if this is something you want to do, and certainly best practice, if you can get the insurance company to give you something that says, we recognize you're doing X, Y, and Z, and that's not a violation of our rules or our contract. It's great. Start early. Try to get that early in the process before you open your doors, because it definitely will take time. And there's nothing that requires the insurance company to bless any sort of arrangement. So you're kind of just at the mercy of if they're willing to do it, and if they have a process in place where they can actually, give you something like that. And not everybody will.
All right, perfect. Well, thanks for joining us. We hope this has been helpful. If you have any questions about concierge practices, whether hybrid or not, please feel free to reach out to Christina or myself. We're here to help you and to answer questions about these type of practices and the laws that may impact your operations. So this has been the Health Law Hotspot. We hope you'll join us next time, and you can check out our other podcasts at ralaw.com. Thanks. We'll see you next time.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.